Hey folks, how we doing? Uh-oh, I don't see anyone here. There we go, there's some folks showing up. How we doing, everyone? You guys hear me okay? All right. How's everyone doing today? Good? Good. Glad to see folks are rolling in. Any of you folks check out John Hyman's Zoominar this morning at 10 o'clock? John Hyman of the Ohio Employer Law Handbook, Ohio, it's been a long week, Ohio Employer Law Blog. Yeah, great. My colleague Lenore Horton from Fisher Broyles just did a Facebook chat on the CARES Act and the paycheck protection provisions there. I'll link to that in the comments below. Hey Robin, how you doing today? Good to see you. This is starting to feel like a tradition. Yeah, let's not keep it that way, huh? Let's get this all cleared up and get back to work. All right. Well, as people roll in, let me do a little bit of introduction here, and then I'll offer my disclaimer. I'll probably have to repeat my disclaimer as people show up, and then we'll get on with the agenda. So again, my name is Eric Meyer. Welcome. Thank you for tuning in today. I publish the Employer Handbook blog that is theemployerhandbook.com. Check it out sometime if you haven't already. Tell all your friends about it. Be sure to subscribe. You get some email updates when blog posts go live each weekday. That's free. You can, obviously you're on our Facebook page. You can check us out on YouTube. We have a YouTube channel. I'll drop a link in the description when I post this. Oh, hey. Dan Blumenthal, how you doing, buddy? Yes, is the T consistent with your employer's dress code? I actually had a court conference yesterday where from the waist up I was wearing a suit, and I was pleased that the judge didn't ask us to all rise. What else could I tell you? I am an employment lawyer at Fisher Broyles. You can check us out at fisherbroyles.com. That's FISHERBROYLES.com. Oh, I see some clients on here. Hey, Cassie, how you doing? Connie, happy Friday from Florida. Happy Friday from lovely Cherry Hill, New Jersey. Weather's nice today, although my pasty skin wouldn't quite indicate that I've spent much time outside. Uh-oh. Dana says this is the highlight of her week. Oof. Oh, boy. No offense, but the highlight of my week is streaming Ozark. Season 3's been awesome. No spoilers, though. Let me give a quick disclaimer while people still fill the room. Quick disclaimer. I am a lawyer, but for most of you, I am not your lawyer. My clients pay me. So what we're doing today is not legal advice. We're not creating any attorney-client privilege. In fact, everything that all questions you ask me, I assume are hypothetical. You're asking them for a friend, and I'm going to answer them as if I'm answering the question for your friend in a non-legal advice giving kind of way. So, if we're cool with that, let's move forward. All right. DOL regulations came out. They came out a few days ago. I'm not going to recap them in full. I'm not even going to recap them much in part. If you have questions about them, there are 124 pages. I've done a video recently, which I posted to YouTube. Again, I'll drop a link to that in the description here once I post this video, and I'll post this once we're done here. We're live right now, but you'll see the recording later on. And thank you, Angela. Good to see you. Love you too. And I will post a link to the video I did on the new DOL regulations. Basically, in sum, they pretty much follow what the Secretary of Labor had been foreshadowing in the Q&A and other guidance that had been posted on the Department of Labor website. So I don't think there were too many surprises. A couple gaps were filled in. I guess I lied. I'll do a couple of highlights. Shelter in place. We do know now that a shelter in place order does qualify under that first prong to get paid sick leave. So a shelter in place order could trigger the requirement or obligation to provide paid sick leave to employees. However, in the regulations, the Department of Labor also said that if folks can telework while they are sheltering in place, and I think we knew this already, but if they can telework, then you don't have to provide them with paid sick leave. If the business is closed down, let's say you're a non-essential business and you're closed down, or you've furloughed employees, or you've reduced hours, you do not have to provide paid sick leave, notwithstanding the shelter-in-place order that's in effect. Basically, think of it this way. If because of the shelter-in-place order, an employee can no longer work, then that's when you have to provide the paid sick leave, okay? So the shelter-in-place order, or, safer at home, whatever your state calls it. I think there's like 30-something of them now. Yeah, someone just asked, is shelter in place the same as stay at home? It is. There might be little variances from state to state, but basically most of the states say that you stay at home, but you're not literally tethered to your house. You can go to the supermarket. You can partake in other essential services. If you work at a hospital, for example, you can go to work. You can go get medical help. Obviously, you can go take a walk around the block. I don't think there's any state in which you're actually literally stuck in your house. But if that shelter in place, safer at home, stay at home, executive order, whatever we call it, if that is the reason you can no longer work, then you may be able to get the paid sick leave. Someone asked, so if we are essential and open regardless of a stay-at-home order, they don't qualify, right? Probably not. I mean, if they still come to work, obviously they don't qualify. If for some reason they're not allowed to come to work, right, and there's no telework available for them, that's the situation in which, they do get the paid sick leave. If they can remote work but can't get a full 40 hours, can they use PSL to make up the difference if they can't go to work? So they can only remote work for part of the time? If the employer and employee agree that the employee can take intermittent leave for working remotely, then that's a possibility. Also, intermittent leave with the employer's approval is available for folks who have to come into the office still, but who need the time off to care for their child who is home from school, or for if there's no daycare. There was a question that just went by that I wanted to see if I can get to. Oh, Marta's question. What if you're afraid to come to work? Ooh, we're going to talk about that later on. I think that's a bigger issue. I have a section of this, or on my agenda, is the big lawsuits that I think are coming down the pike after the coronavirus subsides. And I want to talk about employees who are afraid to come to work, because I think that could lead to particular types of claims which could start to really inundate not only the courts, but also, spoiler alert, the National Labor Relations Board. So, I talked a little bit about the shelter-in-place order, and that's clarified. The Department of Labor also clarified what it means to be a part-time employee and how part-time employees get paid. Please don't ask me to repeat that here. It is long and complicated, and it's in the regulations. And here's a little pro tip for everyone. When you get a copy of the regulations, if you download them from the Department of Labor's website, and you open them up in Adobe Acrobat, turn on the bookmark setting. And then once the bookmark setting is on, you can scroll down to all the different sections of the regulations. So it's not as overwhelming. you can actually skip. You can see all the little sections as they're broken out, all the section headers. So that helps navigate 124 pages of DOL regulations. Those are the big points that I wanted to address. Someone is asking whether furlough employers should apply for unemployment. Yeah, they should. They don't qualify for paid sick leave if you're on furlough. And that's a good natural segue into a letter that Senator Patty Murray from the state of Washington and Rosa DeLauro, the Congresswoman from, state of New York, someone correct me if I'm wrong, wrote to the Department of Labor on April 1st. So let me kind of key you in here. I have this letter in front of me. This was a letter that was written to Eugene Scalia, the Secretary of Labor. And so let's talk about the sequence. On, was it March 31st, I want to say? No, maybe it was March 28th or 29th. Towards the end of March, the Department of Labor updated on its website its question and answers for Families First Coronavirus Response Act. So a lot of us have read that. Those questions and answers essentially foreshadowed what we were going to see in the Department of Labor's final regulation, which came out on April 1st. But in between the Q&A that was updated and posted and the final regulations, Senator Murray and Congresswoman DeLauro sent a letter to Secretary Scalia complaining about or criticizing some of the guidance that the DOL was giving on its website. So here is what Ms. Murray and Ms. DeLauro criticized. And before I give you their 5 criticisms, let me explain to you why these criticisms are important. And they're important because the DOL has given its interpretation of what the Families First Coronavirus Response Act means, right? So basically, the DOL's role is to fill in gray areas, okay? The FFCRA was passed in a hurry. It is clear in some places, not as clear in others. And the DOL's role is to fill in the gaps. So the DOL doesn't always fill in the gaps in a way that everyone agrees with. And sometimes that means the courts don't agree with the way that an administrative agency like the Department of Labor interprets federal law. So the DOL regulations or temporary rule that came out on April 1st, it's not the be-all and end-all. Courts aren't bound by it. Courts generally defer to an administrative agency's interpretation of the law that it is tasked with enforcing. So the DOL's interpretation means a lot, but it's not the be-all and end-all. So against that backdrop, I want to talk about some of the areas that Ms. Murray and Ms. DeLauro think the DOL got wrong. And this is important because if employees also think that the DOL got it wrong, they can bring lawsuits. And if they bring lawsuits and the court agrees with the employees and doesn't side with the DOL, and you're on the other end of that lawsuit, your business, you lose. So let me highlight some of the issues that Ms. Murray and Mr. DeLauro pointed out. The first one is that employers should not be able to require employees to certify in writing that their absences fit one of the 6 criteria in order to take paid sick leave, or fit the single criteria for taking expanded Family Medical Act leave. So basically, their position is oral notice, verbal notice should be enough. Now, we know that in order to get those tax credits, the Department of Labor and the IRS have put out certain requirements, certain basic information that employers need in writing in order to get those tax credits. And what Ms. Murray and Ms. DeLauro have said is that's okay, but getting the actual leave shouldn't be contingent upon providing any sort of documentation in writing. So if you take the position with your employees that you're not going to provide the leave unless they submit paperwork, I think that's I think that's a reasonable position to take. I mean, ultimately, oral requests should be enough, and then they provide the written backup when is practicable. And I think the courts would probably side with you. I mean, at least if you want to get those tax credits. But just keep in mind that it's possible that if you deny someone leave because they don't provide the paperwork to justify the basis for the leave, then that could create problems. Another criticism from Ms. Murray and Ms. DeLauro are that employers should not be able to reduce hours, furlough, or lay off to avoid providing paid leave. And I think that's right. The devil is in the details, though, and motivation matters. So if you are laying off someone who you believe is immunocompromised,